Please give a big warm welcome to Phil Archer, our state attorney.
Thank you, Wayne. You know, we are so fortunate. I've been a prosecutor now for 31 years, almost 2.5 as the elected DA and 28 as a assistant state attorney. And I've had the honor of meeting lots of sheriffs, but I've never met a sheriff that is more dedicated to arresting bad guys, preventing crime, and taking care of our children. So we are very fortunate to have a sheriff like Sheriff Ivey. So very good. And so I was very honored when he asked me to be part of this program, but I would take exception. He'd ask me to do all kinds of stuff, and I'd sometimes turn him down, but he's bigger than me and he has a gun, so I usually do what he says. And so I did jump at this because I think it's really important. And but I'm going to run through. Mine's a pretty short presentation because a lot of it deals with law and stuff, and it's boring as heck. And you know, you just heard a great presentation, and we really want to get to the chain gang that you're going to hear about, because I agree with the sheriff. That's one of the more powerful parts of this program. But we're going to run through a few. We need your help. Law enforcement can't do it all. And when I say that, we talked about it takes the village to raise a child, and we can't. Law enforcement is good at investigating, arresting, and putting people away. But as far as crime prevention and what's going on in the homes, it's very difficult for us to do that. And so we really need the community's help. We need parents to be involved. And we want to prevent your child from being in the system. It's as simple as that. You know, it may save their lives, but once your child gets into the system, it's never a good thing. It's going to follow them. It's going to be in their record. You're going to be dealing with law enforcement, you know, at the level with the police or the sheriff's office. You're going to be dealing with our office. You may be dealing with DCF. You're going to be dealing with Department of Juvenile Justice. All these things come into play when your child gets in the system. We don't want that. We have no desire to deal with your child. We don't want to see him get into that system. So that's why we are trying to come up with some ideas and some things that you can use to try to help with that. Take control of your house. Whose house is it? And the sheriff called it, you know, he talked about that, about taking control of your house, because it is your house. You know, I remember my son from an early age, and he's a little older now, but calling it his room. I was like, you know, and my response was, you know, as long as your feet are under my table, or as long as I'm paying for the roof. And I thought, oh my gosh, I just said what my parents said to me, right? It's like, it's true. It just keeps coming around. It keeps coming around. But, you know, there's a lot of truth in that. And you out there as parents or grandparents, and you work hard and you pay for that house, it just, you know, it killed me when he says his room. I said, no, it's really not. It's my house. It's my room. I own everything in this house. It's not your room. And so you have to remember that, you know, as long as you're sleeping on the roof, feet on my table. So take control. There's a great quote from a court decision, a Florida court that was quoting from another court opinion. And it was in a case of whether or not a father could consent to the police coming in and searching his son's room. And it's just a great quote. A father has the responsibility and authority for the discipline, training, and control of his children. In the exercise of his parental authority, a father has full access to the room set aside for his son for purposes of fulfilling his right and duty to control his son's social behavior and to obtain obedience. Permitting an officer to search a bedroom in order to determine if his son is using or trafficking in narcotics appears to us to be a reasonable and necessary extension of a father's authority and control over his children's moral training, health, and personal hygiene. A lot of fancy words and a whole lot of stuff in there. But that's a very powerful decision. And it, you know, it could father, mother, it could be any term you want to use. But it really shows that the courts are willing to give you control over that situation, over what happens in your house, over the moral training, health, and personal hygiene of your children. It's very powerful. There's another Supreme Court case dealing with grandparent visitation. It was a case that came up. And it says the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. And I always start off this presentation with that, just to kind of give you a little background, that there is some very powerful constitutional protections about what you do to control, discipline, and take care of the care, custody, and control of your children. And I think that's very important, and the courts have recognized that time and time again. It is a big deal for government to treat on how you control your children in your house, and it should be. You don't want us coming into your house. You don't want law enforcement in your house unless we have a legitimate right to be there and a reason to be there to protect either you, your family, or the community. But it is a big deal, and that's why we have those protections about what goes on inside your house. So it is important. All right, how are we going to do it? Search. We already talked about. Search their room. You can search the room. A lot of people don't. It's amazing. I started searching my son's room about 7th grade. You heard Wayne talk about that's when they lose their mind. I think that's probably right. That's about the time he started losing his mind. So I started searching the room. He's 20. He's still living in my house, as my neighbor will attest to. And I still search his room. I don't know if he knows or not, but I don't care. I'm still searching. Have I ever found anything that I felt so concerned that I would have to do something about it? No, thank goodness. Have I found stuff that I wasn't happy about? Yeah. But I didn't really want to let him know because I didn't necessarily want him to know I was searching his room. Unlike one of the things that Sheriff said, letting them know. Sometimes it's good not for them to know because I didn't want him to hide it better. I was afraid. I kind of knew where all the hiding spots were. So, as long as I keep checking those, I was pretty sure that's where where any bad stuff would be. So far, I've been very lucky with that. But search the room. Search their car. Nowadays, lots of kids have cars, and that's where they keep a lot of their stuff. Go in the back in the trunk, open it up where they keep the spare tire. You got a lot of law enforcement officers in here tonight. You probably know some. Ask them. They know where every good hiding spot is in a car. I guarantee you. So ask them. They'll tell you. Their backpack. Every kid has a backpack nowadays, either going to school or going to kids' house, carrying their laptops in them, whatever it might be. Check those frequently because if they're moving around, going from place to place with any type of contraband or anything that they shouldn't have, it's going to be in that backpack. Call the police and give them permission to search. You can do that. Heard that court case. You can do that. But it should really be a last resort, and I'll tell you why. It's saving their life, protecting your family versus bringing them into the system. You should be searching that room. You should be trying to take care of business yourself before you get law enforcement involved. But if you're worried about what they're doing, if it's escalated to the point where you think they have firearms or weapons, or they have a lot of drugs, or there's dangerous people coming in and out of your house, and you don't think you can do it on your own, or you don't have somebody that can help you, then call law enforcement. But I always caution parents that once you do that, you're going to bring the system into play. Law enforcement is not going to come in and search your house and find drugs in your son's room and then just walk away and say, okay, we're done, and you never hear from them again. That's going to cause an issue. And whether that leads to criminal charges or whether it doesn't, it just starts that process. You're bringing your children, bringing yourself into the system. But sometimes you have to do that. If it's a matter of protecting your family, protecting the other brothers and sisters and children in your family, then call law enforcement. If you don't think you're able to take care of that yourself, don't hesitate to call them. And you have that perfect right to do that. I like this one. Let them keep knocking. I need to look up my rights. I like that. Take the door off the room. That's a great way, and again, these are just fun things, we kind of throw this out, but, I can tell you my daughter, when she was younger, about that 12 or 13, crazy teenager years, she had a habit of slamming doors in my face when she wanted to run off to the door, and I kept telling her, you keep doing that, I'm going to take the door off. She did it another time, I took the door off. For a girl, that's incredible. Oh my gosh, she didn't have a door. They can change clothes in the bathroom. You don't have to have a door in the bedroom. And I can guarantee she didn't keep slamming the door after that, So take the door off. It's not going to cost you anything. Pop out the pins and take it off, I guarantee it. But if you're worried about what's going inside the room, if you're worried about other things happening, then take the door off. That's as simple as that. Basic needs. Take their stuff. Here's what's required. Here's what we're going to require of you to provide for your children. Food. And you did a great job with your son, by the way. Just to tell. There's never going to be a complaint to DCF on you guys on that one, so you're fine. Shelter. Make sure they have a good place, a clean place to live and provide that shelter. Clothing. They have to have clothing. Medical, obviously, and education. You have to make that attempt to get them into school. You've got to make that attempt to do that. Because if they're skipping school and you're not making any efforts, you may be in trouble. You may get in trouble for that truancy. So you're required to at least make that attempt, trying to keep them in school. What's not required? Computers. And we talked about that. Of course, every kid has one now. Everybody's got a laptop. And, the sheriff talked about, if you, it's probably a little more radical. I don't know that I would run my computer over that I paid for. But you could do that. It's your stuff. It goes back to, your son saying it's my room, it's my stuff. No, it's not. Everything in that room is yours. You allow them to use it, but it's your stuff. If you want to take it away, if you want to run it over, you can run it over. Maybe take it away somewhere instead. But cell phones. God, every kid has a cell phone now. This is the best one for my stepdaughter. If we want to punish her, you'd take her cell phone. You would think that we were cutting her fingers and toes off. You separate a young person from their phone, it's like the worst thing you can do. So, those are things you have to look at. Cars, obviously, taking their cars away. Video games, that would kill my son. Fancy clothing. There's a great teen court example. We have a teen court program that we started years and years ago, won national awards for, became a model throughout the state. And basically, it's young people that sit on a jury. We bring young people that commit crimes, minor crimes like shoplifting, and they plead guilty. They've already admitted guilt, but they come before a jury of their peers, and that jury of peers decides their fate. And they hear the evidence, and they hear arguments on both sides. We assign them a teen attorney, and we usually sometimes we bring a real judge in to do it. But it's a jury of their peers, and they decide the punishment. And what's great, we had the greatest example of this. We had a young lady that committed a shoplifting crime, and she came into court dressed, just impeccably dressed. Incredible. You could tell that was her favorite outfit, but you could tell she had no wish to be there whatsoever. She didn't get the message. She was mad that she had to be there, just wasted her time. Well, kids, young people can BS us all the time. They know how to get us sometimes, but it's hard for kids to do that to other kids. That's their toughest critics. They see through that nonsense. And so this jury saw through real quick that she didn't want to be there. She hadn't really got the message, and it wasn't taking responsibility. So they went back in chambers, basically, and they come back out after they deliberated. And their punishment was some of the standard stuff, letter of apology to the store, and 20 hours of community service, and standard curfew. And they also said, we also order that outfit that she's wearing, that she has to donate that to the Salvation Army, and we need a receipt for that. That was the most incredible penalty they could have ever given. Her face just went white. She was so mad because the kids knew, that was her favorite outfit. That's why she got all dressed up and came to court that day. And they knew that penalty was more severe. So again, they don't, take their fancy clothing. If there's articles of clothing that they really, really like, and that's the way to get their attention, sometimes that's the way to get their attention. This is a great, I saw this. It said, my promise to my children, as long as I live, is kind of small. I'll read it. I'm your parent first, your friend second. I will stalk you, flip out on you, lecture you, drive you insane, be your worst nightmare, and hunt you down like a bloodhound when needed because I love you. When you understand that, I know you are a responsible adult. You will never find someone who loves, prays, cares, and worries about you more than I do. If you don't hate me once in your life, I am not doing my job. So that kind of says it all. They're going to get mad. They're going to get mad at you, but hopefully that you will save their life or at least keep them out of the system. And again, as long as he lives under my roof. I love that saying. So. Okay, let's talk about physical discipline, because that's one of the things the sheriff wanted me to cover. And, that was kind of where I kind of had a moment of like, what, you want me to tell people how to beat their kids? What are we doing here, Sheriff? Never know with him. I got to make sure what he wanted me to do. But he said, no, I want you to just talk about what some of the parameters are. What does the law say when dealing with it? And I'm not here to promote either way. I'm not telling you to do it. I'm not telling you not to do it. But I do want to give you some of the legal guidelines and so forth. But again, it should be the last resort. You should be trying all this other stuff, all the other things that Ms. Ivy does and the sheriff talked about and all things just a few things that I talked about real quickly. Be trying all that before you get to the physical discipline. And I tell you that because when you resort to physical discipline, it may bring you into the system. No matter how great you think you're abiding by the law. The law is not black and white. There's a lot of gray areas. And so there are a lot of times when you think you're doing the right thing, we may disagree. The officer that comes out to the scene may disagree. The attorney, the prosecutors may disagree. The judge may disagree. The jury may disagree. So try everything else before you resort to that. So many myths have developed over the years. What are some of the quick myths that we're going to talk about real quick? Number one, that you can only use your hand. That's a myth. That's not necessarily true. If that was true, I would have prosecuted my parents for hitting me with a fly swatter all those years. To this day, I cannot walk by a fly swatter without breaking out in cold chills because that was their weapon of choice, And so every time I see that, I think of that. With my kids, the very few times, I can count on one hand the number of times I used physical discipline on my children. It was the wooden spoon, because it was in the kitchen, it was easy to get to, and long enough, and and so forth. But yeah, it doesn't have to just be your hand. So it can be a belt, it can be a switch, depending on the size of it, and so forth. But is it preferred that you use your hand? Absolutely. Is it preferred that you use something that, like a belt, or a fly swatter or something that's what we consider reasonable? Yes. What you can't use, baseball bats, iron rods, big branches, and we'll talk about some case law about some other weapons that has been used. Only on the bottom, that's another myth. That's the best place to do it if you're going to use physical discipline. You will have less problems if you only spank someone on your child on the bottom. But unfortunately, sometimes you miss. Sometimes you hit the back of the legs. Sometimes there's other areas you hit. So that's a myth also. But you can't hit them in the head. We're not going to look kindly on blows to the head, or blows to the back of the neck, or blows to the kidneys. There's different, or to the genital area. So there's a lot of areas that you have to be very careful about. You can't leave a mark. That's another myth. Unfortunately, when you do use physical discipline, you're probably going to leave a mark. It's the duration of that mark. Does it leave welts and bruising that last for days and days? Does it draw blood? The switch on the back of the legs drawing blood. That's probably not a good thing. We probably could prosecute Mrs. Williams nowadays. We wouldn't, because I don't think you guys wouldn't prosecute them, so we'd probably be all right with that. But yeah, you can leave a mark, but and we'll talk a little more about what type of marks and so forth. And you can't do it out of anger. Yes, it would be great if you didn't do it out of anger, if you would take your time, wait a while till you calm down, but realistically, how many of you are not going to do it out of anger? It's going to be right then, you're going to be mad, and you're going to do it. That's okay, as long as you follow some of these guidelines that we're going to talk about. To prove the crime of child abuse, we have to prove two elements. That the defendant knowingly or willfully, intentionally inflicted physical or mental injury upon the victim, or an act that could reasonably be expected to result in physical or mental injury, or encourage someone else to do so. And the victim was under the age of 18 years. That's it. Very simple definition of child abuse, and that's what I talked about before. Unfortunately, it's not always black and white. It's a very wide range of things that can happen. However, if it is a parent or legal custodian that raises the defense, if he's being prosecuted and he raises the defense that he was disciplining the victim, then the court will tell the jury the following thing. They're going to tell the jury it is not a crime for a parent or a person who has legal custody of a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from that discipline. That's what the jury is going to tell. That's what the judge is going to tell the jury. You have to take that in consideration. Even though there's a physical injury on this child, was it done out of disciplining, and was it reasonable physical discipline? And what's the key word up there? Reasonable. And that's again, the gray area, because what you think's reasonable may be totally different than what I think's reasonable, what the agent that comes out to investigate the complaint of the child abuse. Reasonable. What is reasonable physical discipline? Who decides? Well, a lot of people are going to decide. Department of Children and Families investigator that comes out is going to make some initial determination of whether or not what you did was reasonable. The police officer or deputy. And it's very difficult for officers. Officers are trained that no one is allowed to batter another person. And especially now with domestic violence and being such an important issue, when they come out and somebody's been battered, it's usually a crime, and somebody is going to get arrested and somebody is going to jail. So it's very difficult sometimes when it's a parent disciplining a child. And so the officers sometimes deal with those difficult, conflicting basis of procedures about, okay, you can't batter someone, but if you're a parent and it's reasonable physical discipline, you can. So it can be very difficult. The assistant state attorney, if the DCF and the agent, and they all agree it was child abuse, then that case is going to come to my office, and then one of my prosecutors is going to look at that case, and they're going to make a decision of if it was reasonable or not. And then at some point, a judge is going to look at that, if it gets that far. And then if it gets past a judge, then a jury of your peers are going to determine with what you did was reasonable. Factors that will be considered. These are things that we're going to look at, law enforcement's going to look at, my office is going to look at, judge, whatever it might be, whether or not it's reasonable. The age of the child. Obviously, that's going to be an important factor. If you're, physical discipline on a 2-month-old is not going to be the same as physical discipline on what a 16-year-old or 17-year-old or 13-year-old and so forth. Age of the child is always very important. Any prior history of injuries to the child. If there's constant physical discipline going on and you're causing constant injuries, that's going to be a factor that we're going to look at because that's going to go against being what's reasonable. The location of the injury on the body of the child, like I told you. The bottom is the preferred area, but we're going to look at where are the injuries. If the injuries are to the head or to the face or to the neck, to the elbows, to the knees, those very vital, important areas, that's going to be a problem. The number of injuries. How many times did you hit and strike your child? The duration of the discipline. If it's a couple swats and it's done and it's over with, like the sheriff was talking about, that's probably going to be reasonable. But if it goes on for 5 minutes, 10 minutes, 30 minutes, an hour, there have been some horrific cases of parents tying up children and beating them over a period of hours or days. Obviously, that's not going to be reasonable. The type of instrument or method used. Whether did you use a baseball bat? Did you use it? And I say that not being funny because we've had cases where parents have hit kids with baseball bats, or the flat side of a machete, or some incredible things that that's something we're going to look at. Many courts have used the phrase "typical spanking." 2011 case, the court held that before looking to the child's injuries, you must look to whether the actions were reasonable corporal punishment. And in this case, the defendant repeatedly struck the child across his back and arms with a belt containing some metal objects in the belt. You've seen those belts, the studded belts. And so the court there said, we're not even going to, before we even get to the injuries, was it a reasonable spanking? And so they were looking at the type of instrument that was used, and they held in that case that was not reasonable because of the instrument that was used. It cannot be likened to a typical spanking or other form of reasonable corporal punishment. In a 2007 case, the court confirmed a conviction where the parent pushed the child to the floor and then kicked him in the side, even though no significant injuries. Again, it wasn't the injuries, it was the method of punishment. Using his foot to kick a child when they're on the floor on the side. As a matter of law, it was not a reasonable corporal punishment no matter what the injuries. So it's not always just the injuries. That's another important factor we have to look at. Okay, the type of trauma inflicted almost always will be considered unreasonable if it results in the following: sprains, dislocations, or cartilage damage, bone or skull fractures. Those are if you have that, you're going to get arrested and charged. Brain or spinal cord injuries, injury to the internal organs, suffocation, drowning. I skipped that first word because I have trouble saying that one. Injury resulting from the use of a deadly weapon. Again, if you hit somebody with a baseball bat and cause an injury, you're going to get charged. Here's some other ones. Burns or scalding, cuts, lacerations, punctures, or bites, permanent or temporary disfigurement, loss of impairment, significant bruises or welts. That's in Florida statutes. Those are things that we're going to be looking at to determine in the case law. If you have any of those, then it's most likely you're going to get charged. I'll finish up. There is no guidebook. It's a case-by-case basis. I wish it was clear. I wish we could hand out a guidebook to you tonight and say, okay, this is here to follow. Maybe you should write one. That might be good. But maybe not. Some of that stuff probably wouldn't work. I wish there was, but there's not. It's going to be a case-by-case, but you got to use your common sense. I mean, it really is what it comes down to. Stay within that typical spanking and reasonable physical discipline guidelines. If you're using your hand, if you're using the fly swatter, a paddle, and you're spanking to the bottom, short duration, it's a reasonable age that you're doing this, you're not leaving significant welts and bruising, you're probably going to be within that parameters. Know that you have rights, and you can take control of your house. And just finished up, again, you do have rights. You need to know that. You can take control of your house. And if you're not sure about what you can do, you can call law enforcement sometimes and ask them those questions, and we'll try to help you as much as we can. But you got to understand, we're limited in what advice we can give you. We have to kind of wait till it happens, unfortunately. That's the way it works. But, get with your pastor. There's a lot of children's groups and parent right groups that can help you explain some of those rights as well. But you do have rights. You can take control of your house. And thank you all for being here and participating in this program. And